We can't allow the court system to have a chilling effect.
Senator Kennedy.
Thank you, Mr. Chairman. Thank you for being here. Professor Mascott, this case that we're talking about, Trump v. United States, it was before the United States Supreme Court because the Biden administration decided to criminally prosecute former President Trump. Is that correct?
Yes, Senator.
And in fact, President Biden's lawyer actually asked for expedited review and an expedited decision by the Supreme Court. Is that correct?
Yes, the prosecution would have found expedited review helpful.
When the court handed down its opinion, well, strike that. The title of our hearing is, quote, "When the president does it, that means it's not illegal." And Chairman Durbin explained what he meant by that, but I just want the record to be clear. Did the Supreme Court, in its opinion, ever say, quote, "When the president does it, that means it's not illegal"?
No, that doesn't
Okay.
appear in the opinion.
All right. At the oral argument of this case, President Biden's lawyer actually conceded, did he not, that core functions of a president should have absolute immunity?
Yeah, I do think there's agreement that core functions should have immunity.
In fact, President Biden's lawyer said, quote, "Core functions can't be regulated at all."
That's correct.
Close quote.
Yes.
Okay. What is forum shopping?
Forum shopping is the act of trying to find a court that you think is going to rule favorably to you.
Does it go on in the United States?
Many folks think that it does.
Yeah, it does. It's hard to stop. Let's just stipulate for a moment that America's withdrawal from Afghanistan was not a model of efficiency. People died, including Americans. Can you imagine a scenario with respect to President Biden, now former President Biden? Can you imagine a scenario in which a district attorney in a jurisdiction that repeatedly voted overwhelmingly against President Biden and whose voters did not like President Biden? Can you imagine a scenario in which an ambitious district attorney, after President Biden is out of office, could bring a charge against former President Biden for criminal negligence in the death of Americans? Can you imagine that?
Well, Senator, that would be very troubling, and so that's one of the things.
But can you imagine it happening?
I could imagine district or attorneys wanting to bring such an action, sure.
I mean, now that we've decided that former presidents can be prosecuted, this current case before us is the first instance, but I fear it's not going to be the last. Now, let's suppose this ambitious district attorney in an anti-Biden jurisdiction or venue decided to prosecute former President Biden, which I think would be a mistake. But he meaning former President Biden, would have to defend himself, wouldn't he?
Yes,
And suppose he won, he'd still have to pay his lawyer, wouldn't he?
that's true.
Are lawyers cheap?
Only those of us who teach
No,
law.
strike that. I know they're cheap. Are they inexpensive?
No, they're not.
So President Biden could spend millions of dollars,
That's true.
even if he won.
Yes, sir.
Now, let's suppose after that trial was finished, another ambitious district attorney in another venue or another jurisdiction decided to do the same thing. And then another, and then another. Can you understand what the court was talking about when it said we can't allow the court system to have a chilling effect on a president, any president, in making these decisions? Can you understand that?
Absolutely. The risk of facing that would certainly significantly impact how a president would make decisions in office, and that's the last thing we want.
Can I have 30 more seconds, Mr. Chairman? I don't want to mispronounce your name, sir. Don't count my fumbling around against me. Mr. Lacavara,
Never have.
you were vociferous in your criticism of this opinion that the words presidential immunity don't appear in the Constitution. Is that right?
That's part of it, yes, sir.
Do the words separation of powers appear in the Constitution?
No, I acknowledge that there is a structure called the separation of powers.
Is there any doubt in your mind that we have separation of powers in the United States Constitution?
No, and I think it's important to understand what the separation of powers does and does not imply. And
Right.
what it does not imply, in my judgment, is the kind of immunity that the Supreme Court established here.
Okay. Thank you, Mr. Chairman.
Senator Cruz?
Thank you, Mr. Chairman. The nub of the Democrats' argument today is that the concept of presidential immunity is somehow unprecedented, is somehow remarkable. That claim is utterly ahistorical and disconnected from the entire constitutional history of the Republic. General Mukasey, before 2023, how many times has the President of the United States been indicted?
None.
Before 2023, how many times has a former President of the United States been indicted?
None.
In the last 2 years, how many times has President Donald J. Trump been indicted?
4 times, I believe.
Now, many presidents of both parties have engaged in controversial actions, and yet none of them have been indicted. Let me ask you, General Mukasey, if a private citizen were to erect an internment camp and to forcibly kidnap American citizens, to single them out because of race, and to imprison them based on their race, would that private citizen be subject to criminal prosecution?
Would.
When President Franklin Delano Roosevelt did the exact same thing and erected Japanese internment camps, was FDR prosecuted?
He was not.
Let me ask you, similarly, if a private citizen were, say, to detonate a nuclear weapon over a city and kill over 140,000 people, and then if that private citizen a few days later detonated another nuclear bomb over another city and killed 75,000 people, could that private citizen be criminally prosecuted?
He would.
Was President Harry Truman prosecuted for detonating nuclear weapons over Hiroshima and Nagasaki?
He was not.
All right, how about this? If a private citizen launched a weaponized drone and killed a United States citizen, could that private citizen be criminally prosecuted?
He would.
Was President Barack Obama criminally prosecuted when he killed United States citizens using drones without notice and without due process?
He was not. Although, as far as due process is concerned, I believe the comment of my successor to that question was that Anwar al-Awlaki got, quote, all the process that was necessary.
Well, although I suspect he might disagree with that assessment were he able to present his case.
Right.
All right. Let's contrast that with the rules that govern other federal officials. You were a judge for 19 years. As a federal judge, did you have immunity from your official acts?
For my official act, yes.
Do federal prosecutors have immunity from their official acts?
They do.
Now, the distinction between official acts and personal acts is not a terribly shocking distinction. Under the decision of Trump versus United States, if any president walks onto the sidewalk and just shoots a citizen, is that president liable to be prosecuted?
He is.
How about this? If a president steals funds from his campaign, does that president face criminal liability?
He does.
How about this? If a president sexually assaults, let's say, an intern in the Oval Office, is the president subject to criminal prosecution for that?
He could be.
So that distinction, again, is not a shocking distinction. The Founding Fathers vested the executive power in a single president of the United States. What we have seen in the last 2 years is we have seen Democrats deliberately weaponizing the Department of Justice and our legal system to target their political opposition. It is not an accident that every indictment against President Trump was brought by a Democrat and was brought after he announced his campaign for President of the United States. Understand, the target of those indictments was not ultimately President Trump, it was the voters. It was prosecutors who were terrified that the voters would choose to re-elect President Trump. One of the great things about the United States is we're not a banana republic. Since 2000, the nation of Pakistan has had 6 former prime ministers prosecuted and convicted. Brazil has had 3 former presidents arrested and imprisoned. Last year, Nicaraguan President Daniel Ortega arrested, charged, and imprisoned 40 political opponents. General Mukasey, you are Attorney General of the United States. Is it the proper role of the Department of Justice to prosecute and target the political opponents of whoever happens to be President of the United States?
It is most assuredly not.
Thank you.
Senator Rono.
Thank you, Mr. Chairman. I thank all of the witnesses. We have a Supreme Court majority busy overturning decades-long precedent, and so let me cite some of the better-known decisions, and I do this as illustrative of the Supreme Court's willingness to overturn precedent as well as create new precedents. For example, in Citizens United, we learn that corporations are people and opening the floodgates, basically, to the dark money that is flooding our elections. In Shelby County, we see the Supreme Court eviscerating a major part of the Voting Rights Act. And in Janus, the Supreme Court overturns decades-long precedent that enabled public sector unions to collect fees even from non-members who they had to represent. Excuse me. I heard mentioning of Korematsu. The thing is that when the Supreme Court makes a decision, even if it's wrong, it can stand, and the Korematsu decision stood until 2018. So when the Supreme Court makes a decision, it has ramifications of longstanding. Then we have Brnovich, which, again, it further limited the protections of the Voting Rights Act. And by the way, did I mention Shelby County, where suddenly the majority decided that to eviscerate, as I said, the Voting Rights Act, and soon thereafter, 13 states passed all kinds of voter suppression laws, and under Brnovich, they went even further. In a more recent case, Bruin, the Supreme Court, again, decided that to sustain gun safety laws, they should look to precedents going back to 1791. And of course, we have the Dobbs decision, which overturned almost a 50-year, what women in this country thought was a constitutional right that the Supreme Court should be protecting. More recently, in 2023, we have the Harvard affirmative action case, which the Supreme Court tossed out, meaning that Harvard's ability to refer to race as a way to have a more diverse student body, that was tossed out. And then, because of the outcome of the Bruin decision and all of the aftermath of that, there was another case where they had to kind of walk back their Bruin decision. And then we have the more recent 2024 decision where the Supreme Court overturns a Chevron decision, and that's going to create all kinds of problems. And now we have the Supreme Court creating new precedent in terms of presidential immunity, and this is going to have far-reaching consequences. And of course, you know, it's already having impact, totally foreseeable impact on the Trump cases. In the DC case, the parties are briefing issues raised by the Trump decision, and Judge Chutkan is going to have to make certain fundamental decisions on that. There's no question that this immunity decision helps Trump. In the Florida case, it was totally dismissed by Judge Cannon based on, of all things, Justice Thomas's, it wasn't even part of the majority decision. So there, it's like, wow, that just raises so many questions that she would toss out the case based on Justice Thomas's concurrence. And then we have the New York case where Trump is wanting to set aside all 34 convictions. So we have a Supreme Court that is making these kinds of far-reaching decisions, and in this case, I don't see how anybody can say that it doesn't help Trump. So I have a question for Ms. McCourt. You know, I think you went into this a little bit with the questioning from our chair, but if you can't bring in the motivations, regardless of whether the motives may have been based on his responsibilities as the president, how can you prove that the president was doing things that should hold him criminally liable?
Well, certainly mens rea that includes specific intent to commit a crime, and that is an element of every one of the crimes that's charged against Mr. Trump in the January 6th prosecution. That's required at trial. The Supreme Court has actually said, though, that you can't even look to motive when determining whether the allegations involve official acts or purely private acts. And again, I think that hamstrings the judge in even making those determinations, because if you can't look at the intent, it makes it very difficult to determine in some cases what might be on which side of the line.
So if we look at the pragmatic and practical impact of this immunity decision, I don't see how a prosecutor can overcome the immunity of the president if you can't bring in motives. So as far as I'm concerned, this is a decision that should not be allowed to stand. What do you think about a constitutional amendment that would make it very clear that no one is above the law, including the President of the United States? I asked that of Ms. McCord.
Yes, I'm familiar with your and your colleagues' proposed constitutional amendment, and I think that that is something, you know, that legal scholars can study, but it seems like it is a response that to this opinion. I would note potentially the need to carve out actual core constitutional powers, but I don't think the amendment was necessarily intended to override those.
Thank you, Mr. Chairman.
Senator Grassley.
I'm leading up to a question for Professor Mascott, repeating a little bit what Senator Lee just said. For the last several years, the other side has ratcheted up the political rhetoric against conservatives and other countries in our country's democratic institutions. More recently, they've directed their focus and ire on the U.S. Supreme Court. They've dubbed the Supreme Court as a MAGA court. They've referred to the current member makeup as somehow radical. The Senate Democratic leader threatened to release a whirlwind, as you know all about that statement. Unfortunately, this has all come as a tremendous cost. Justices and their families have endured ongoing picketing outside of their homes, scenes of public intimidation, harassment, and now death threats. Needless to say, this is all totally unacceptable. So to you, Professor, does America have a MAGA Supreme Court, and how would you describe this characterization?
Well, I mean, we have a Supreme Court, and I agree with a lot of what the senators have said and Chairman Graham, where I believe every justice on the Supreme Court's trying to carry out what they believe their constitutional duty is. It's coming under unprecedented attack, which we have not seen, in many years, with breaches of confidentiality across the branches, people facing attacks and threats. And I think it's our, duty here testifying today and setting these actions to do what we can to make sure that they're portrayed in an accurate light and be careful and studied with what they talk about. With respect to this current decision, as you know, the Supreme Court doesn't reach out to take cases. It takes the cases that come to ed. And what prompted this was really the unprecedented nature of the criminal prosecution in this case of the current administration prosecuting a current political rival.
Okay. Judge Mukasey, could you briefly describe how the recent Supreme Court presidential immunity case builds upon previous legal precedent and doesn't give the president the authority to have political enemies terminated?
Well, as I pointed out, there is Nixon against Fitzgerald established the principle that there are that there are immunity principles that apply to the presidency. This is a logical extension or plausible extension of that decision. Marbury versus Madison pointed out that the decisions of the president are not subject to examination by the courts. The notion that somehow the president is immune from prosecution for imagined acts, I think is way beyond what the majority said. Just to offer a less dramatic, but nonetheless equally far-fetched example, if the president, as commander-in-chief, ordered the military to shoplift a tie that he wanted to wear to deliver the State of the Union address, that would not be something that is for which there is immunity. Yes, he's commander-in-chief of the armed forces, but shoplifting is not among the prerogatives that he has to order.
Judge Mukasey, can you briefly explain some other attempts to exert political pressure on the judiciary and what was the results of those?
Well, there have been, as was pointed out, there have been threats to limit the budget of the judiciary. There have been threats to strip the judiciary of its jurisdiction, and I think those are very dangerous, and ultimately will wind up damaging the liberties of all Americans.
Professor Mascott, broadly speaking, can a federal statute overturn a constitutional interpretation by the Supreme Court, or would a constitutional amendment likely be required?
Well, in our system, we treat the interpretations by the Supreme Court as a final judgment. So a federal statute, no, would not overturn it. You would need a constitutional amendment, and that's intentional because of the high bar that it takes with the support of 3/4 of the states to be able to get a constitutional amendment, to be able to override previous understandings of the Constitution.
I yield back.
Senator Welch.
Thank you very much, Mr. President, Mr. Chairman. At the heart of this seems to be a core dispute about whether presidential power needs immunity in order to be effective, powerful, and unconstrained, or whether presidential power within the Constitution, adhering to the doctrine of separation of powers, adhering to the doctrine that no person is above the law, needs constraints. The majority in the court made several comments that suggested, actually explicitly stated, that they wanted no constraints so that they could have, as they put it, a vigorous presidency. Justice Roberts disregarded what or diminished the importance of the facts. He said in a memo, in a case like this one, focusing on transient results may have profound consequences for the separation of powers for the future of the republic. our perspective must be more farsighted. Justice Kavanaugh said, I'm very concerned about the future. Justice Gorsuch said, we're writing for a rule for the ages. And General Mukasey, you said you expressed a concern about the powers of the presidency being whittled away. My concern is that the rule of law is being whittled away. My concern is that constitutional freedoms are in the process of being whittled away. What's been whittled away are the checks and balances that are the core of our constitutional system. And Mr. Chairman, what's being whittled away is the Article 1 responsibility of Congress to enforce the rule of law. General Mukasey, I want to ask you to just comment on some of the hypotheticals. I mean, with all due respect to you, and I have enormous amount of respect for your service, talking about ordering the military to steal a tie that you want to wear at the inauguration, I think really diminishes the importance of this. What about a president ordering that political opponents have the IRS pursue them? Is that acceptable or not?
It is not.
So should the president have immunity for that?
The president is, first of all, politically answerable for that kind of behavior.
We're not talking about that.
I know that.
Well, then don't say it.
Okay. I withdraw the comment.
Thank you.
The ordering the IRS without basis to focus its activities on political opponents.
Well, why in the world would the President of the United States, who's got a lot of things to deal with, decide that person A or person B should have the IRS go after them? How in the world, in what world would that be legitimate?
It is not legitimate, as I said.
So should he or she get immunity for that?
No.
All right, what about the professor's recitation of Nixon's focus on going after Jews in government?
Again, no.
So no immunity for that.
Correct.
But under this decision, Professor?
No.
All right,
I gather that question's not directed at me.
No,
Because the answer to that is no as well.
I did direct it to you, but I want to ask Professor McCord.
Senator, I think this is what's left open by the decision. Because the Supreme Court capaciously defined these core constitutional powers as absolutely immune, it opens the door to the very types of activities that my colleague, Judge Mukasey, agrees should not have immunity. Now, there could be other readings, but the Supreme Court doesn't tell us those, and we're left wondering exactly how far this opinion goes.
Well, thank you. You know, Mr. Chairman, this is not about the court. This is about us. It's about how much confidence we have in our capacity as a democracy to govern ourselves, as opposed to transfer that responsibility without limitation to a person in an office who has not traditionally been above the law but subject to the law, and whose responsibility is to serve us and not use authority to abuse us. I yield back.